Trusts reputedly can be traced back to the Spanish Crusades. They started for the purest of reasons to ensure that family were taken care of. Parents' ability to know their children is unbelievably bad. How do you think they'll cope when you've died? And her response was, well, they'll just have to, won't they? And it's like, dear client, you ain't seen nothing yet. When families fall out, that changes their lives, that changes generations. If you settled a trust, you're about 335 times less likely to be bankrupted than someone who had not. And the court said, we've been hearing that argument for over 400 years now. Hasn't worked any time then, is it going to work now?
Have you seen anyone settle a trust and their intention was good, but it actually created more harm than good down the path?
Yes. The classic scenario there would be
Today's conversation with Vicki Ammundsen is an absolute cracker. Vicki has been recognised as being the leading lawyer in New Zealand on trust and estate law. She's recognised in the Chambers list globally, which I'm told is the place to be as a lawyer. She's a litigator, she's a settler of trusts, she's my trust advisor. She's forgotten more things about trusts than most of us will ever care to learn about. If you have money or if you plan to have money, then you probably want to be considering what a trust is, how it works, why it's important, and how to get one going. We do a deep dive into that subject today. Vicki's very generous with her sharing and her insights. She's a great storyteller. She's got a very impish and a fun sense of humour about her. So I reckon you'll take a lot away from this conversation and have a great time. Vicki Ammundsen, arguably one of New Zealand's best trust lawyers. I'm so looking forward to this conversation. Welcome to the show.
Thank you. Very pleased to be here, Josh.
What a pleasure. Hey, so they say that the only certainties in life are death and taxes, and you've managed to craft a career that's into the intersection of both of those things. Is that like a macabre interest with the dark arts or just a coincidence?
I think the best answer to that, Josh, is if you look to my dogs, Morse and Agatha.
I love that. Morse and Agatha.
Correct.
Okay. So a real fascination with all things kind of law, investigation, finding out solutions to things, I'm guessing as well.
Absolutely. And if I wasn't a lawyer, my dream job, I'd be a paid assassin.
Is that right? You've actually answered my very last question first. So we've flipped this entire podcast on its head. That's wonderful. Thanks for coming to the show. So
I guess I'll be leaving now.
Yeah, that's exactly right. Yeah. Hey, so let's go back to the start, Vicki. So I think there's probably quite a lot of misconception about what a trust is and how it works. So what is a trust and why would someone set one up?
I agree that there's a lot of misconception. And the reason for that is we talk about a trust as a commodity. We talk about, my trust, his trust, her trust, their trust. But actually, a trust, there's no such thing. A trust is not a legal entity. And a trust is a relationship between the trustees and the beneficiaries.
So unlike a company, which can be a legal entity and has the rights now of a person in a lot of senses, a trust is very different from that perspective.
Correct. So the trustees are the legal face of the trust, and they carry out what the settlor's wishes are. The settlor may or may not be a trustee, but it's that relationship. And why do we have trusts?
Yeah.
Trusts reputedly can be traced back to the Spanish Crusades, and the original trusts were called a use. And those early trusts developed because back then land could not be bequeathed by will, and so right back, some very smart person worked out that, the odds of coming back from the Crusades were not good. And so he reached out to a friend and said, hey, mate, I'm off to the Crusades. We all know what that looks like. So here's my land. It's not for you. I want you to hold it for my wife and children. And I expect there was a little footnote that says, in the unlikely event I come back, give it back to me. But that was because otherwise the land would have gone back to the feudal overlord, and the wife and children would be destitute. No social services back then. And so I think that's part of why trusts always have this slightly bad rap, this idea that, you're hiding something. But really, they started for the purest of reasons to ensure that family were taken care of. And over time, trusts have become the only way assets can be held and not decimated on death. Because whether you're in a society where you can't bequeath by will, or perhaps you've got forced heirship, or there's other constraints on what you can do, trust to the extent permissible in the relevant jurisdiction. When you die, there's probably sadness, might be a funeral, nice send-off, maybe a little memorial plaque somewhere, but when there's a trust involved, your death doesn't mean anything. The assets remain with the trustees. There may be a change of trustee, but the assets aren't decimated. And so that is why trusts have been able to build huge wealth, because rather than decimating assets on the death of a key individual, they remain to benefit the family and to grow. However, there's a little but. Trusts in most jurisdictions do not last indefinitely.
It's 120 years in New Zealand?
125 years now, up until the Trusts Act, 80 years, apart from charitable trusts, which, like a company, can last indefinitely. And so you've still got to be managed. So while you can say, well, okay, we've got these assets in trust, we've got these great trustees, and we're managing it, for the wider family, this is great. You can't just sort of stand by and not ensure that the family aren't properly educated, because at some point, the assets are going to come out of trust solution. They may go back in and start the clock ticking, or they may not. And so the element of trust that's often overlooked, trustees are bound by the Trust Act, the terms of the trust deed. The really important thing is managing the beneficiaries, managing their expectations, managing their education, because while all of the beneficiaries probably won't be trustees, they all need to understand the part they play so that the entire structure can operate the way it was intended.
Yeah. You mentioned along the way that they historically may have had a bit of a bad rap, and you said concealing, hiding of assets. I'm guessing that's either from creditors or from current, maybe soon-to-be future ex-partners, for example, from kids, other things. What are the reasons do you think that people had a negative perception of trusts?
There was a big uptake of trusts in New Zealand in about the 90s. We had the early adopters in the 60s. And a lot of those trusts commonly didn't have independent trustees. They were families that had recognised this is a way to grow wealth within the family. Some of those trusts achieved great growth and development of family wealth. In the 90s, it started, oddly, after estate duty. And so estate duty had been a driver of trusts because of concerns about it. But we didn't still have a lot. And that were those early sort of 60s, 70s trusts when we did have estate duty.
Essentially death tax?
Yes. But why it was never really such a big deal is we also had gift duty. So you couldn't, no matter how much wealth you had, you couldn't put it all into a trust. You could only gift at that point at $27,000 a year. And so the transition of that wealth was quite slow. But oddly, the uptake when we no longer had estate duty, that was when a lot of people were a bit like, what if we came back? So that was actually quite a big driver. And also, if I manage the transition of wealth into a trust correctly, if I need state care when I get old, if I manage it well, I have a trust, I'll get a residential care subsidy. And we had differential tax rates. That meant there could be tax advantages having assets in trusts. But you've actually got to have quite a lot of income to make it worth it. And you've got to look at if your goal is to pay less tax, but the corollary is you lose control of the assets for that benefit, you've given up everything to maybe pay a bit less tax. Tax as a driver for trusts has, I think, always been the worst of reasons. Likewise, getting a residential care subsidy. If your sole goal is to get a subsidy, to get some subsidised care, the average time in care might be, depending on the stats you look at, 9 months to a year and a half. You're going to manage a trust, have all of those annual expenses for something that might not happen. The only good reason to settle a trust is to hold assets for the long-term benefit of one or more people. It might be really little. You might have a family member, a child. You might have a child with special needs or a child who's vulnerable, and you want to make sure that that child is protected. But then really, we don't always know the things that are going to happen. While it might be obvious if someone has special needs, well, they need protection. A lot of other people need protection from themselves. There's a lot of wealth that can create, going into new relationships can be quite challenging. And so it's commonly trusts have been used, increasingly unsuccessfully, to protect wealth from a relationship breakdown. But it's very different if you've got significant family wealth and their spouse or partner is potentially a stranger to the family. The optics behind protecting the wealth in the event of a breakdown, it's quite different to I've got wealth that I have generated during my relationship that my spouse or partner doesn't know about, and I'm just keeping it over here. And so that's the ones that are really have fallen foul of the courts. And when the court is challenging trusts, or it's before the courts to say, is this trust, is these assets available to the spouse or partner? What the court's looking at is, first off, did you have a relationship property agreement that actually said, look, I love you. I love you so much. Oh, everything that's mine is yours. But if you leave me, I take it all back. And the problem with that, and I think in a lot of some of the high net worth families who maybe have a family office, which isn't a common occurrence in New Zealand, they're very big on the first sniff of a relationship. Right. We get the lawyers in, we have a relationship property agreement.
It's also known as a prenup for those that are unfamiliar with it.
But it's got to be fair. And what might be fair for a 6-week relationship, 30 years later and 5 children, and I walk away with the clothes on my back I had when I arrived and anything I might have been gifted, we've got to keep it real. And so trusts are the only way you can protect assets for the long term, but you've got to keep it real. And they can protect assets from creditors. But if I've been served proceedings and I think, time to do a little bit of housekeeping, I think I'll set up a trust now. It's too late because the Insolvency Act will apply. So if you put assets in a trust to defeat your creditors, it can be clawed back. So it's about being real and looking at what are you really trying to achieve? And any time it's to defeat something, you're probably going to come a cropper.
Yeah. And so talking about that situation, the use case, if you will, the appropriate one for establishment settling of a trust is to put assets in a secure place, maybe governed by a series of rules for other people at some stage in the future. The alternative to having a trust is essentially going through a will situation, isn't it? If you want to bequeath and pass something on, albeit that they have some quite big differences between them. Could you point out those differences between something that might be, end of life, someone has a trust versus someone that has a will?
Yes, there's 2 things to it. Most trusts in New Zealand are what are called discretionary trusts, and that's why they're so valuable, because the beneficiaries get what they're given, but they've got no rights to those assets. If they are the final beneficiary, most trustees will have a mechanism for who benefits at the end, but usually the assets have been disposed of along the way. So a final beneficiary has what's called, very catchingly, a future contingent proprietary interest. But that just means they've got certainty that at the end they may get a share of what's left. A will really works the same way, because a will is prescriptive. Trustees, your executors don't have discretion. Your will says, when I die, this is what happens. However, we have the Family Protection Act. And so if I decide I'm not providing for all of my children equally, or I'm not providing for my spouse or partner's got the choice of, under the Property Relationships Act, to say, I don't want what I got under the will. I want it treated as if we had split up, and I want what I would have got under the Act. And so on death, the spouse or partner can make an election. And if you decide, you might have good reasons not to provide for one child the same as the others, but legally under the Family Protection Act, your children can say, Mum or Dad have met the duties that they owe me. Grandchildren have similar rights, although the threshold is higher, and also stepchildren, but only if they were being sustained at the time of death. And so one of the problems with wills, particularly with blended families, they can be a very blunt instrument that doesn't always work. You might deal with that by having what's called a mutual will, where a surviving spouse or partner has basically promised they won't change the will, and they can work. But again, they are prescriptive, and the court can decide not what would I have done if I was the will maker? But have you met the obligations that you owe that child? And so, whereas with a trust, if you dispose of your assets, even up until the day before you die, to a trust, so long as you've got capacity, weren't acting under duress, the flexibility, who you intend to benefit can be achieved. Whereas under a will, it might not be.
We're kind of circling around a subject, which is one that I was keen to explore this season, which is the notion of death and then what happens post-death to your estate. And so I have a perception that wealthy folk, self-made folk, may have a little bit of a reticence to talking about their estate, talking about death, or is that actually a universal human thing?
It's a very universal human thing. Sometimes wealthy people are very uncomfortable talking about their wealth, particularly with family. I've acted for lots of families where it's not until there is a death of a parent that they discover how much wealth was in the family. They may have lived a really simple life, and getting huge wealth later in life can create some problems. One, they may not have the skills to deal with it, and it can create real bitterness. If I'd had this wealth sooner, I could have done all these things. But it's a very New Zealand thing. We don't talk about our wealth. We don't talk about our success. I've got clients who, to them, the worst thing in the world would be ending up on the rich list. And when it comes out each year, I have a little chuckle, because there is so much wealth in New Zealand that no one even knows is there. But the real problem with death is, if you are the owner of that wealth or the business that generates that wealth, say you've got 4 children, and you may have made a will that, the assets are divvied up between the children, that may require the destruction of the business. So to meet those bequests, a really successful business that employed huge numbers of staff, generated lots of delicious tax for inland revenue, is destroyed, because that's what happens when you die. Your assets have to be broken up. Now, your beneficiaries might want to keep the family business going, but from my experience, it's very hard to have all of your children on the same page. And there was a case a little while ago where it was a trust coming to an end. They're the final beneficiaries. They all had those future contingent proprietary interests, and there was a very valuable business. And what was held, the trustees were holding the shares. 3 wanted it to continue, and 1 said, I want mine. And they argued, but this could destroy the business. If we lose this much of the shareholding, we're going to create vulnerability. And the court said, not our problem. This person is entitled, this is an asset that can be divided up. They're entitled to call it up. So sometimes, no matter your best endeavours, it's not always going to be achievable, but recognising that, and so that either you can put other arrangements in place, or do the best you can to educate the next generations so that they hopefully make the smarter decision. Now, one person's smart is not the next person's smart, but I think, and you can't keep everyone on the same page, but by trying to involve, I think, family more and educating them so that they are better equipped to deal with wealth, and also to have some support around them so that they don't become prey to all of the hands that come out when suddenly there's unexpected wealth, or wealth they've been sitting there waiting for.
It's interesting. You and I went through a process of remapping one of my trusts half a dozen or so years ago, and I think it was our first kind of key engagement. And you talked about a lot of it, as you know, is going to provision for charitable foundations. That's the intention of it. And since doing that, actually at the end of it, you said to me, thank you for doing this. And I said, oh, boy, that's curious. Why are you asking me? And your response was, I don't know if you recall, but it was that most people talk about doing this, but they don't often get to doing it, and especially not at your age. So do you think that people have a bit of a blind spot around the willingness to think in the very long term about it, and then consequences of either going to family or to friends or to dogs or to, trust and that sort of thing? Do you think that's something that people think through or not?
You raise a really good point. Some do, some don't. I review lots of trust deeds where there'll be a named charitable beneficiary, and I'll ask, so is this, what are your wishes regarding this charity? Oh, well, no, we just put it there to look good. Interesting. But I think, globally, there is a huge push for wider philanthropy. It's not something, again, that families often talk about. You do get a lot of pushback. You might have a trust where there's a mixture where the memorandum of wishes, which is a way that a settlor can say, when I've died, while I know that my wishes are not prescriptive, what the view from the courts is that those wishes, it's not that the trustees must follow them, they must know them, they must understand them, and they've really got to have a very good reason not to. But if you don't have those conversations and all of the family is not on board with those philanthropic wishes, or you don't structure it correctly, they can be thwarted. One of the most important cases we've had in trusts in the last few years is a case called Grandview Private Trust and WOG, or WAG, depending on which jurisdiction you're in. A lot of wealth, and the beneficiaries got about $100 million US, and the trustees felt that was enough. So they then appointed a charitable foundation, removed the beneficiaries, and transferred the remaining $500 million to the foundation. Many would say, well, $100 million is nothing shabby. But sometimes when you're looking at $500 million you didn't get, $100 million doesn't seem like very much. And once you look at the cost of buying a jet, fitting it out, not a lot left over. Exactly. And so that decision was challenged. And the Court of Appeal that was heard in the Court of Appeal Bermuda, very similar law to New Zealand, and the Court of Appeal there said, well, they had the power, they could do it. It was then appealed to the Privy Council in the UK. Now that we have the Supreme Court, we no longer have appeals to the Privy Council, but it's very important law from a New Zealand perspective. What the Privy Council said was, yep, if you've got a power, you can use it, absolutely, but it must be by references to the purposes of the trust. And so that residual control the settlor has, why the trust is being settled, and there was a lot of evidence in the case of the settlor's views regarding philanthropy, which is such a hard word to say sometimes.
I agree.
And how important it was, but it wasn't embedded enough in the terms of the trust to actually save that distribution to the foundation. And so when we settle trusts, not just going and get that commodity, Vicki, just give me a trust. I didn't have time to talk about it. Josh said you're pretty good at this. Just give me a good trust. But I need to know why. I need to be able to draft it and record either in a memorandum of wishes, or if you want those wishes to be really bedded down and prescriptive in the body of the trust deed, what it is that you want to achieve. And of course, sometimes though, it goes a different way. You can have settlors who aren't that interested in outside the wider family. The family may feel different. And I have been involved in trusts where you've got trustees who are confronted by beneficiaries who are saying, yeah, thanks. Thank you, we've got enough. I don't want any more, but what more can our family do? And for some trustees, that can be quite confronting because they've never had those discussions with the settlor, and they've got beneficiaries who are actually leading the discussion. And another way beneficiaries can lead it might be the investments. So often we might be dealing with the sale of a business and suddenly a whole lot of wealth, but sometimes it can be quite different where you've got an investment model that's very successful, but the beneficiaries are saying, yeah, that's great, but can't we do better? Our investments, they don't look, and we talk about ours because, well, it's not really the beneficiaries. Everything is held for them, and we are getting beneficiaries now with maybe a more advanced social conscience who are saying, well, there's a whole lot of money there, but we're not really that happy the way we made that money. Yeah. What can we do now to do better? And so that sometimes there can be a real tension. And so while often the focus is on locking up the money, making sure the beneficiaries don't get too much, don't get too greedy, don't just sit back and do nothing because the trust will take care of me. And Vicki, what do you mean? What am I doing about a job? I don't need a job. The trust will take care of me. Sometimes it goes the other way around and you've got beneficiaries going, I've got enough. Can we do more?
Great question. I've become a ponderer on the notion that I came across in a book called Die With Zero by Bill Perkins. And he postulates that rather than building up this big estate and then accumulating wealth over the course of your life and spending little bits and pieces of it, and then endeavoring to resolve the problem of where to put it at the end of your life, obviously leading to that point, he advocates getting rid of it along the way. So spending a third of it, giving a third of it away to charitable foundations, and then a third going to the family is kind of his rough rule of thumb, give or take. But in other words, rather than waiting until your death moment for your kids to have this windfall, give it to them progressively, because at 30, they need to buy a house. At 65, when you die, they've probably accumulated their own money, they've paid down their own debt, they've taken their kids through college and bits and pieces like that. And so the utility ability of that money would have been much greater when they were younger. So in other words, find the causes that you care about along the way and then continue to drip feed money as you go over the course of your life. What's your view on that? That seems like an un-Kiwi thing to do based on my perspective, which is much less than yours, obviously.
I agree it probably is un-Kiwi, but it's very sound. And again, it comes back to the conversation. And of course, the more it's more attractive, the more wealth there is. But if you think of the case that I've Grandview Private Trust, if that had been managed that way, far more likely the settlers' objectives would have been met. We wouldn't have had the great jurisprudence, but it comes back to that conversation and not shying away from money. A lot of clients I have, they're happy to help children into houses. They may be happy to help them into businesses. They often like to keep a debt back though. They want to know that they've still, because it is that control thing. It is that I'm going to help you, but on my terms. And there can be a real reluctance to actually lose control. But I think if we have these conversations sooner and we focus more on our children's financial education, sometimes social education, I think we could becoming a lot more rounded society. That said, New Zealand, we have a very high number of charitable trusts in New Zealand, the same as we have vastly more trusts per head of capita than any jurisdiction in the world, is the general accepted view. We also have a vastly high number of charities. So we are a very giving country, but the way we do it often maybe isn't fully collected or recognised.
Mm-hmm. So you mentioned having regular communication, being clear on what your expectations are. What else would you do to suggest people around that kind of issue that you just highlighted there?
Have good advisors around you. Have good advisors around your family. Recognise that the advisors that have helped you grow the wealth, they may not resonate with your children, or depending on your family construct, your nieces, your nephews, or even the charities that you want to support. Sometimes you've got to look at the advisors that helped you grow the wealth. As you start dealing with the fund spending part of it, have you still got the right team around you? And you may or you may not, but also the people who are going to be dealing with whoever you want to benefit, whether it's through a trust, whether it's through a will, making sure that they're going to be in safe hands. If you're going to do it through a will, have executors who will resonate with your children, rather than maybe someone who you think, well, you're a good lawyer, therefore you'll be a good executor, or you know all about administering estates. Is that going to be the right mindset to help your children navigate with their wealth? And so it's keeping it under review.
Yeah. Let's just do a quick glossary. We'll pause there for a second. So settlor, the person that writes the trust.
Yes.
Beneficiary, the recipient or recipients of the proceeds of the trust. Trustee and executor. Could you give me the...
So the trustees of your trust are the legal face of the trust, the owners. In an estate, you have an executor, often also referred to as a trustee, because when you die, the person who takes care of the administration, calls in the assets, you're an executor. But then if you have sometimes you might have a testamentary trust. So if we go back to maybe that special needs child, you might decide, look, Vicki, a trust isn't for me, but I do need to take care of this child. So you might say, the will might say that when they die, it's divided into 4 parts. maybe one part goes to charity, two parts, part each to each of the surviving children. The third child, that last part might be held by your executors, who then in the capacity of trustees, who will hold that money or those assets on trust for that child.
Okay. Makes sense. And so what do you need to be conscious of when you are selecting your trustees, and because they sound like a critical person to get right, and the executors? What kind of process would I go through when I'm thinking about considering who the right people are?
With trustees, I say to clients, and this particularly if they're saying, Vicki, would you be my trustee? And the question I have is, okay, I'm your trustee, we're making a decision. You say, hey, Vicki, we should do this. We should sell this, we should buy this. How will you cope if I say no? How are we going to manage disputes? Because that's how if I agree with every single thing my co-trustees want, maybe I've just got the best co-trustees ever and we're just all on the same page, but it means I'm probably dialing it in. Or I'm doing the classic rubber stamp. Well, hang on a minute, Vicki, you're just the independent. You can't stop me. You're just here because, to make it look good. It's how are we going to deal with conflicts? And so with a trust, that's the question I ask to sort of trying to establish what's the right construct of people here. And it also comes down to what are the assets? Who's going to have the skills to manage the assets? And sometimes you might have, while I don't like huge groups of trustees if I can avoid it, there might be a trustee who's really going to be the interface with the children or the grandchildren or the charities, depending on what the purposes of the trust are. There might be the one who's got the skills for the particular investments. But then if we change investments, they might have great institutional knowledge. Are they still the right trustee? Do we need someone else? So often trusts keep the same trustees for a very long time. I don't like a prescriptive requirement to change because A, it always gets overlooked. Run lots of court cases when it turns out that none of the trustees are validly appointed because all of their terms ran out. But realising that there may need to be change over time. We've got to pivot because of a change in circumstances. It's keeping it fresh.
Mm-hmm. It sounds like it would be picking a trustee, if there was a reasonable amount of assets involved, that it's very akin to a board of directors. So they have the ability to either be quiet and sycophantic about things. Typically, you wouldn't want that to be the case anyway. But if you assemble people through a skills matrix approach and you appoint professionals that understand their domain very, very well, they have skills around certain areas, be it investment or governance or relationship management or whatever it might be. And then you go through a process of those folk understanding what the flow of assets is, how the money's managed, what the intention of that vehicle might be, and then be proactive around it. Is that a fair analogy for me to draw?
Yes. And trustees, under the Trusts Act, we have default and mandatory duties. And so trustees actually have a lot of responsibility. They have a duty to actively, unless they modify it, to actively consider how to exercise their powers. And so a lot of people think that being a trustee is an honour. Oh, thank you so much for asking me. That means so much. It's actually just a big headache.
Yeah.
But it's a headache that you either like to embrace or maybe you shouldn't be doing it. Because what a lot of trustees fail to understand, they're liable in the first instance. Any decision they make, if it's a bad decision, they can be personally liable. And most trustees think that anything they do, they're protected by the trust. But they're not. Because otherwise, how are those beneficiaries protected if the trustees can make a terrible, terrible decision and not be accountable for it?
So worst case scenario is that a beneficiary could potentially sue a trustee, is that correct?
Correct. Because a trustee might have made a really bad decision and they might have a trustee that says, doesn't matter what you do, Josh, I don't care if you're negligent, you're my trustee, you're protected. The Trust Act says, even if the trust terms say you can be negligent, you're grossly negligent. You don't have any indemnity. Because there's got to be some checks and balances. And often, trusts, there is a power imbalance because essentially the trustees, they're the gatekeepers. The same way that the directors are the gatekeepers of a company, the trustees are the keepers of a trust. Beneficiaries do have some rights, but they've got to enforce those rights. The only way to enforce them normally is to go to court.
Yeah, wow.
And so it can feel quite one-sided, but a lot of trustees are starting to learn that they overlook the beneficiaries at their peril.
Mm-hmm. Directors can carry D&O insurance, directors and officers insurance. Is there such a thing for trustees?
You can get trustee insurance, but it is very difficult. If you're a professional trustee, your professional indemnity insurance may extend your trustee appointments. There are some insurance offerings that provide insurance for trustees, but they're not that common. And the same as with directors, though, you can't get insurance for workplace safety. And so if you own risky assets as a trust, you might insulate that by having a holding company and looking really at the management of that holding company. But there are some risks, even as a trustee, you cannot protect yourself from.
Interesting. So many founders conflate their identity with that of the business. So when it comes to conversations with you around death and succession planning and estate planning, how do you help them separate those two things out, and what do you see in relation to that space?
First off, in the trust space, we have something called founder syndrome. And that's this idea that someone is the big all I am. It's about management, and it's about starting it at the start. It's getting it across that you've set up this trust to achieve these things. So how are we going to do it? It's keeping the conversation going, because often people set up a trust with the best of ideas. But then reality happens. And a classic might be, you touched on earlier, creditor protection. I'm going to be in a risky business. Workplace safety is a good example. You might be thinking that I might start offering more director services. So I'm going to protect my assets for my family before I do that. And so that's not an uncommon strategy, but then there is a claim. In my entire career, I have had one trustee, who is also a settler of the trust, who has chosen to be bankrupted rather than then go to the trustees saying, a bad thing's happened, I want my money back.
He was the settler as well.
He was a settler as well. That is the only time I've had a client just decide to be bankrupted, because while trusts are often put there for protection from creditors, that's the idea. If you're bankrupted, it's not a lot of fun.
No.
If you're a director, you can't be a director.
No.
You can't travel without the official assignee's consent.
50,000 income per year, I think, is the limit.
Everything you do is going to be micromanaged.
It's like being in money prison.
It pretty much is. And so the idea of it versus the reality, that's when you really have to face up to it. But one of the really important things is, when we settle a new trust with clients, we circle back really early on, and we start off with 3 monthly meetings. And that might sound a bit of overkill, because often the first one they're too busy. But at least if you try for 3 monthly, you might get 6 monthly, because it's keeping people on track for what they started before they start to go off track. Because things change. But also, if you recognise at the start, when I'm no longer in business, the concerns may no longer be valid, I might want to exit then. If that's what you want, draft it that way. Have that in your memorandum of wishes. Don't just say stuff to make it look good if it isn't actually who you are.
Mm-hmm. When someone with a large estate dies and it comes to your attention after the fact, what are the things that surprise you about how that estate has been handled? What are some instances of things that have been like, whoa, what have they done here?
The left hand and right hand not talking is the classic. It might not even be a large estate. It could be a really small estate, where reverse mortgages are not that common in New Zealand, but nor are they that uncommon.
Reverse mortgages are where you take a mortgage out on your home that is probably debt-free, and the bank gives you the money, and then they take ownership in the home over time, right?
Correct.
Yeah.
And so they're not very common if with a lot of money, but they are with more modest estates. That's great. So if you do that, wouldn't it be really good to mention that in your will? Because the classic is, mum and dad take out a reverse mortgage, and they may have told all the children, and the children say, the children are fine. The children say, yep, we totally get it. We don't mind, we don't need it. But then one of them dies, and maybe it's a blended family, and there might still be 100,000 left in the facility, and the deceased says, I'd like to draw some more from the facility. No. And maybe the children are also executors. No, we don't agree with that. Dad wouldn't have wanted that. That was only for when you were both alive. Would have been really helpful to pop into the will whether or not it is okay for mum to draw down on that life interest,
Right.
on that reverse mortgage. Another thing I think with wills, if you've got business assets, think about where's the debt and where are the assets. One of the things that is quite problematic now, a lot of people will have a mix of assets. There'll be some in the trust, there'll be some personal, and it might be really considered. These are my personal assets that are going to these people. Here's the trust. Here's the memorandum of wishes. That's what happens with the trust. And on paper, it might look brilliant. But what if when you die, you owe the trust $2 million? Because the trust was paying out all this money to you, and no one was thinking about, should it be a distribution, or should it just be a loan, or what is it? So it just gets recorded by the accountant in the accounts as a loan, when actually, and you weren't really thinking about it. Sure, you signed the accounts, but no one really thought about it. So when you die, you owe the trust $2 million.
Where does that come from?
Well, that's okay, because you've got assets worth $2 million. It's all right, except
That was in the will.
all of the beneficiaries under your will are going to miss out up to the tune of that $2 million because you're going to have to pay that back to the trust. Because your will didn't say, your will might say, I forgive any debts owing. So if the trust owes you money, you've forgiven those, but you haven't thought about, but what if I owe money? And so, and what if, so then, or you might have this valuable business asset, but you've also got some loan debt, but you haven't said, where is it going to be funded from? So your memorandum of wishes might say, this is who gets the house, this is who gets the business, this is who gets the shares. It looks great. But you haven't thought about where the debt is, or debt was taken on that you hadn't really had time to get around and make some changes. And so you end up with the skew because the debt's going to get repaid, and that might affect how your wishes are going to be carried out.
Interesting. I shuffled around on my chair uncomfortably there because that could be my situation. Assets in both the trust and in my own name. So when you talk with people who are considering going about the business of setting up a trust, they come to you to establish that process. What are the common misconceptions that you have to rectify for people?
That it's a magic umbrella, and that I have a trust and I'm protected for life. One of the worst things that happened in New Zealand was the abolition of gift duty. And I'm not saying that because of any particular political leanings.
Yeah. What is gift duty? When was it?
We had gift duty. Gift duty was abolished back in about 2011.
Oh, wow.
Up until then, and that's why trusts up until then were quite well managed.
That was the $27,000 a year. Got it.
And so while people hated it, it was the best thing because every year your clients came in. Your clients would come in, and this was before COVID and before we did everything by Teams and Zoom. Your clients would come in to do their gifting, and they were like clockwork because it was per calendar year, and you couldn't backdate it. And if you delayed, the time it would take to gift off the transfer of those assets to the trust would be delayed. It forced a level of administration and compliance that otherwise, I think has since been overlooked.
As a consequence, are you now seeing things where trusts have not been tended that well? And so it's a bit of a mess.
You get the client coming to my office, Vicki, I've got this creditor claim, I've got this judgment against me, I've got a trust, so I know I'm okay, but can you just want to check? And you look at the accounts and you go, but you still owe, the trust still owes you $800,000. Oh no, I'm pretty sure I told the accountant to gift that off. No, I think the accounts are wrong. But you've signed them the last 5 years. And so when gift duty was abolished, Inland Revenue put out a revenue impact statement. And because they're required to do that, when you've got legislation that has effectively some kind of impost, because that means they're no longer getting gift duty. It's one of the big reasons for abolishing gift duty. It cost more to run the gift duty unit than revenue made in gift duty.
Right.
And so it wasn't considered a very helpful or useful duty. But the numbers were really interesting. And what you could glean from some scratch math from the numbers, if you settled a trust, you're about 335 times less likely to be bankrupted than someone who had not.
335 times.
Now, in my defense, I'm dyslexic. And so while I understand math, I'm not saying that my sites could be flawed.
88% of stats are made up on the spot as well. So yeah.
That was my assessment of it. And I came up with 3 reasons for it.
Okay.
1, if you're living on the street, long-term asset and estate planning is probably not your
Top of the list.
That's not your big thing that you're worrying about. Second, trusts have had a fortress effect. If you're going to challenge someone and there's trust ownership, it is always going to be harder. Even if you've got legal right, there is going to be more that you're going to have to do. But the third, I think, and it does circle back to what we've been talking about, is you had advisors around you. You talked to your lawyer or accountant about these things every single year. And so you had this support network that you little problems got nipped in the bud before they became big problems. And so while I'm sure many people wouldn't thank me for saying, Vicki, are you mental? Why would we want gift duty back? But it made people focus their attentions because there was the stick. Every year you didn't gift was longer until you had the holy grail of getting assets into trust. And what I see now is that people might have forgiven that first deed, but then they might have received an inheritance and they think, well, I'm going to transfer that to the trust. But instead of gifting it and documenting it, they just put it in there.
Chuck it in there.
They just tell the accountant, oh, there's another $1 million in the bank account. And no one says, oh, is that a gift? Is that a loan? And so some of that housekeeping that really helped us develop good, well-managed trusts has been a little bit eaten away at.
Yeah, interesting. So what, in your mind, would be a sensible personal remedy that someone who had a trust in place right now, in lieu of the gifting thing being removed, what should they consider about a better way for them to look after the trust, given that?
Either having active administration around them.
Yeah.
Some people are not geared up to have an independent trustee. And I really like the clients who, because there's no legal obligation to have an independent trustee, and I much prefer clients who are honest. When they're confronted with the discussion, what happens when your trustee says no? Well, then I'll just remove them and get another trustee.
Yeah.
Well then, how is this really going to work? So if they're going to be the trustees, having the support around them and making sure that the advisors are cohesive so that everyone knows what's going on, having permission, having it recorded in your letters of engagement, that the lawyer can speak to the accountant, can speak to the fund manager, can speak to the directors, so that there's no one, coming back to your analogy of the advisory board, all of the people who need to know things are in the know, and you've got an early warning system so that if there's trouble, we don't wait until we see the financial statements, which might be almost 2 years after the problem started, that we trust the people around us to sometimes talk to each other, even maybe before they talk to us, so that we're in a safe group of hands.
Thanks for listening, and apologies for the interruption. I wanted to share with you that this show is one that we, the team, collectively pour a lot of effort into. There's resources that are involved. We have producers, promoters, and wonderful guests that share their time with us so that you may learn and possibly, hopefully, make some impact on the world as a result of that learning. The only thing I ask of you is go and check out my website. There's a diagnostic tool on there. There's a free downloadable chapter of my upcoming book, remarkably called 2 Commas. And there is some other fascinating resources that I'm not going to tell you about because you need to go to the website to check them out. So thanks for listening, and please continue enjoying the show. Anecdotally, there's situations that I've come across or heard about where people are trustees, they don't know what the assets are, there should be some income that's being recorded that's not being taken care of, there's decisions that are being made without going through a proper decision-making process. My observation is for people is that, and this is a demographic thing to a certain extent too, baby boomers specifically, that they don't like having the conversations about it. It's money, we don't talk about money, there's some death that's looming, we don't want to talk about death either. And so what I'm hearing you say over and over again is make sure that you have the right people that are giving you structured, sensible, relevant today advice around you, and have regular dialogues about what it is that your intention is, what we're planning to do, where we'd like to go, because this is the chance to do it.
And if you don't like everything they say, that might be the sign that they're the right person. We've got the history of trusts is peppered with cases. I'm just the passive trustee. And we've got some where they've actually said in evidence, well, I didn't want to know what was in the trust. That's personal. I mean, they asked me to be the trustee. I'm fine with that, but I didn't want to know how much money there was. That's personal. There's a case a few years ago where Inland Revenue had ended up missing out on some money from a trust and was a bit cross. And an independent trustee actually had to put hands in own pocket and pay money to Inland Revenue, quite a lot. It was a bit sad. So then sued his co-trustee to get the money back. And his argument in the court was, I was the passive trustee. I didn't know what was going on. It's not my fault. He took the GST. I thought he'd paid it and he hadn't. And the court said, we've been hearing that argument for over 400 years now. Hasn't worked any time then. Is it going to work now? You and just for anyone out here who is a trustee and is starting to feel slightly uncomfortable, what the court then said, but fair call, you are entitled to recover some of that debt from your co-trustee. But notice the word some, not all. Apart from very limited circumstances, trustees, they share that liability jointly and severally. So they said you're allowed to get half of it back from your co-trustee.
Wow.
But that's because you share it jointly.
Which, when you reflect upon the influence, the power that they have over that trust, it makes sense that they have to take the onus of that responsibility, right?
Yeah.
And one of the things I vividly remember from university, the law papers I had to do for my accountancy degree, was ignorance of the law is no excuse.
No.
Unfortunately. So a part of your practice is litigation. So obviously that's in the trust law space. So people are unhappy with the result and they start that journey of litigating to get a result that they believe is the correct one. And I know I'm not endeavouring to ask how long is a piece of string question here. What I'm endeavouring to get across here is that if you don't have the regular conversations and structure the trust in the right way and be clear about what your intentions are, then the alternative is that you wait until there's an event, probably a death or something similar, and then you go to court. Is that expensive?
Hugely. Even and this is where sometimes being beneficiaries can be a problem, because beneficiaries do have rights, but they're going to have to spend money to file proceedings. And the sort of rule of thumb that we use is just getting a claim filed. If it's relatively straightforward, that might be $25,000, but that just gets your foot in the door. Then, and often the goal might be to get to mediation, but you might not. Then you might get to the first call, and or you might have a small fixture to sort of like scope out the issues. Then you might be up to about 45, 55,000. Then you might be looking at a 1 or 2 day fixture. So then you might be up to 80, 120,000 plus. And the problem with trusts and estate disputes, they're very rarely binary. So if you've got a commercial dispute, you've got, I say you breached the contract, you say you didn't, and either you're going to have to pay me some money or not. But then the civil standard, if I'm successful, you pay my costs, but normally that's only a proportion, or if I'm unsuccessful, I'm going to pay a proportion of yours. It's often believed in the trust and estate space that, the trust will just pay. And you can get orders from the court in advance determining whether or not the trustees will be indemnified. Beneficiaries can seek orders that they'll be indemnified, but that presumes they've got the money to do that.
Yes.
And so then at the end of the day, you'll get one way or another. Ultimately, you either settle or you get a result, but the real sticker can be costs. And often for beneficiaries, the starting point is, I need more information until I know what my issues with the trustees might be. One of our longest running just cases involving beneficiaries seeking information, the costs there are in the millions.
Wow.
And we know that because those decisions are in the public domain. And there was one costs order that was well in excess of $1 million.
Phenomenal.
And that was one where the trustee was a company but the order was that the costs could not be met from the trust fund. And so the costs can be, they can be absolutely eye-watering because you've got all these parties. And so what we often say in our firm is that you can look at your basic costs in a basic dispute. Once you've got multiple parties, they increase almost exponentially because you might be dealing with, we deal with matters, we might be dealing with 4, 5, 6, 7, 8, 9, 10, 12 represented parties.
Wow. And each of those represents expense.
Which means that trustees who try and game it and say, well, we'll wait till the beneficiaries do something,
Yes.
or beneficiaries who maybe pull the pin too soon, a mediated or negotiated outcome is almost always going to be better because you end up almost invariably, at the end of the day, you get a decision. I get some lovely jurisprudence to blog about, but the collateral damage, those family relationships hardly ever survive.
It's brutal, right?
It's really brutal. And I mean, I've got a new nephew in my family, and so we're all, looking at the delicious new nephew photos, and I've been doing some aunt duties, which is lovely. Imagine what sometimes I think of those families and where we've been involved and we know that there's been another, an important event in marriage, birth of a family member, and we know that there'll be family who aren't going to the wedding or who aren't going to the christening or who aren't being sent those photos because the fallout from these disputes is so nasty.
Mm-hmm. Funding those things, by the way, back to the case of if you do decide to take the case to through the legal process, then hundreds of thousands, potentially into the millions of dollars. Wealthy folk, I think there's a misnomer from the outside that they have millions of dollars of cash lying around the place. They don't. It's tied up in assets, right? You got wealthy for a reason. You invested in some things, and so it might be real estate, there might be some stocks. Those are a lot more liquid, but it could be tied up under some form of thing that doesn't allow you to get access to it. And so it's not like it's really easy to go and get millions of dollars to fund this type of exercise. Which leads me to a question. I'm interested in alternative investment classes of a variety of different types, maybe for myself, but certainly at an intellectual level. A good friend of mine, a lawyer, he's one of the funders of a class action lawsuit in the United States. And there is hundreds of millions of dollars that's at stake here. The judgment was coming out in the last couple of months or so, or sometime soon. And he put in, it was, I think, something in the region of $250,000 to fund, in part, some of the expenses to take this case all the way to whatever court it was being presented at in the United States. But the return for him would have been 10x on his money. And I kind of go, is there a trust fund that you'd like to set up taking trust through the court process so outside investors could go, millions of dollars sitting in there, I might chuck in $100,000 and see what happens and see if we can get out.
We do have some legal principles in New Zealand that make funding and profiting from litigation. There's a little bit, we do have some judicial views on that.
Is it dirty or is it actually not allowed?
Calumny, it's actually a thing that basically profiting from litigation is something that we're not allowed to do.
Fascinating. Is that in part why we don't have the litigious culture here that Australia and the United States does?
Possibly in part, and in part because some of the things that we would cut our teeth on, because of ACC, we don't have a culture of you hit my car and then I broke my leg and now I can't, do this, so I'm going to sue you. Because we have ACC, we're not raised on civil litigation.
Yeah.
And so and I know that, love or hate ACC, there's much good about ACC.
Couldn't agree more.
But it does mean that we don't kind of like cut our teeth on, that's the normal cut and thrust. But when you're talking about alternative dispute resolution, better ways of managing disputes, one of the things that I sort of bemoan is that we don't have a trust ombudsman. I do feel a lot for beneficiaries who've got rights, but they can't unless they can, afford to promote their rights. Then, sometimes some can be really ridden over pretty roughshod by trustees. And I think we do need better forums for these disputes, not just because I think we're always going to have that imbalance. But if you've got a shareholder dispute, you've got the Companies Act.
Yeah.
But as a beneficiary, you've got all these rights, But then if you're going to enforce them, you're going to have to foot the bill.
Yeah.
And shareholders might be in the same position, except that they've already got something. The beneficiaries, there's a pool of gold maybe, but are they going to get enough back to make it worth it? And so I think some better mechanisms and drafting trust deeds as well, contemplating disputes so that you've got mechanisms for dealing with it so that litigation isn't your only option.
Yeah, makes sense. If you've written a lot of texts on trusts, you've been blogging for a dozen years, you have a webinar series that you do as well, 20 odd per year. So you've got some views on trust and you like to share those with the world. And thank you for doing that in this fascinating and clearly much more complex space than I thought it was. You mentioned a trust ombudsman would be something that you would advocate for. What other changes would you like to be able to see if you could make some changes into the Trust Act in New Zealand? Is that what it's covered under, an act?
It's the Trust Act, and I have raised my views on a trust ombudsman, and I've had many people tell me what a stupid idea it is and how hard that would be. But what I think if there is going to be one change I could make in the Trusts Act, having more an easier means of triggering alternate dispute resolution at a low level where there's greater bargaining equality between trustees and beneficiaries, so that there is level the playing field. Not all beneficiaries are good, not all trustees are bad, but if we could level that playing field a little bit so that, and because if you and I have a business falling out, then that might be the end of our business relationship, but it probably won't change our lives. When families fall out, that changes their lives, that changes generations. And, while I cry my crocodile tears because the money that comes from a trust or estate dispute spends just as well as the money that comes from drafting a lease or a memorandum of wishes, we are not immune to the human fallout that necessarily goes with part of what we do. And that's, I remember an early case that I won, and I was terribly proud until I shared it with my mother, whose comment was, "Well, I think you should be ashamed of yourself, Vicki. I think what your clients did was terrible. I think the other side was right." Well, Mum, there were some quite technical points of law, and I was applying the law, and the judge agreed with me. "Well, I don't think your father would have liked that either." Well, thanks, Mum. How was your...
How's your day? Yeah, exactly. So do you think that people with assets, and particularly founders that own businesses, do you think that they mix together their personal estate planning with that of the business? They kind of get those two things confused and overlapped too much?
I think so.
Yeah.
But sometimes people think the answer is lots of trusts.
Right.
A trust for the house, a trust for the business, a trust for this. It's more about, and I think going back to what you said, when you die, what do you want to happen? Or if you are no longer running the business, what do you think you need to do to keep that business that you've grown safe? Or if the business gets sold, what are you going to need to make sure that those proceeds are dealt with properly within the family? It's having that conversation. But the other thing is, we talk a lot about what happens if you die. I've had more clients lose capacity to head injuries than old age. And so sometimes things happen that it isn't a death, but from a practical perspective, it's just as catastrophic. And that is where, if you've got a great will, that's not going to help you because you haven't died. But if you've got a well-structured trust and with appropriate trustees, the protective mechanisms, because often when settlors are settling trusts, they expect to be benefited along the way. They expect that their interests will likely be paramount, but they often don't consider the possibility that they're not going to be the person making the decision. And so sometimes things happen that haven't been contemplated, and it isn't just death that needs to be confronted.
Mm-hmm. I suspect I know the answer to this, but how risky is it for someone to consider and have this as an opinion? I've told the kids what I want, but never documents what that thing is. How risky is that?
Well, it's really good for funding my personal plane.
Yes.
Parents ability to know their children is unbelievably bad.
Right.
Parents who sometimes some parents are really smart. I've got parents who they'll tell me they know what their children will be like, but I also have parents who get it staggeringly wrong. I had one client, we're doing some asset and estate planning, a lot of wealth, and some children worked in the family business, some did not. And their longer term plans were that the children would be their attorneys under enduring powers of attorney, would be their executors, would ultimately be the trustees. And we're putting together some planning. And one day I said, let's start talking about what this will look like. The children are all the trustees, executors, attorneys, whatever scenario. What is how are they going to work together? Like, do we have any issues with the different management styles? Well, they've never gotten on, Vicki. Did I not tell you that? No, you hadn't mentioned that. So let's just drill down on that a little bit. What do you mean they don't get on? It's my great sadness. My children have never gotten on.
Oh, wow.
I don't know why. That's why this one works in this business and this one's in that business.
We kept starting businesses so they wouldn't have to run across each other.
They just don't get on. And I said, well then, how do you think they'll cope when you've died? And her response was, well, they'll just have to, won't they? And it's like, dear client, you're seeing their party manners. You ain't seen nothing yet. So you just have to take off the rose-tinted glasses.
Yeah, very much so. Have you seen anyone settle a trust and their intention was good, but it actually created more harm than good down the path?
Yes.
Mm.
The classic scenario there would be protecting assets from a spouse or partner, but not revisiting when it's become a long duration relationship, or they've made contributions. They think that they're part of this joint thing, and they know there's a trust, but then over time they think that they are a trustee, they are a beneficiary, and then something happens. There's either a death or a relationship breakdown, and the person who has been just as much a part of that for a long time discovers that they've got no rights. And so some trust can create unfairness. The other is blended families.
Right.
And so you've got a trust where there's children from different relationships, or possibly children that have become part of the family and aren't actually legally children at all, considered children.
Yes.
But then the trustees aren't all of them, and you get them favouring one side of the family over the other, or totally disregarding a side of the family. And those ones can be really brutal, where the intentions were really good, but the terms of the trust have enabled one side of the family to get control, and then the other, if they don't have the resources to seek legal redress through the courts, are completely stuck.
Mm-hmm. We've talked around the subject, but I'm just going to ask the question directly. What is it that you think that people, this is your opinion, that people get wrong about leaving money, leaving resources, assets to their kids?
That they'll make smart decisions.
Mm.
Outside the trust space, one of my sisters has a friend who was diagnosed with a terminal illness. Terribly sad, large insurance payout, and she gave her children an early inheritance. And she didn't die. And now she's running out of money, and 3 of the 4 children have lost the money through relationship breakdowns, bad investments, living it up because they didn't know how to handle the money.
Wow.
So it comes back to that, the education. And sometimes, well, I often say, plan for the worst, hope for the best. And actually, sometimes the worst might not happen. So if you just plan for that, you can make some really bad decisions.
Mm-hmm.
A lot of it's about balance.
Right.
Give the kids a bit, see what they do with it.
Yes.
And then maybe a bit more, rather than, here's $3 million, fill your boots.
Best of luck. Mm. I had a wealth manager, Nick Crawford, on the show a couple of 3 months ago, and his notion was around people that have come into sudden wealth, the windfall moment. In the UK, he dealt with lottery winners, reasonably big market there, much more so than here. Really fascinating conversation. In New Zealand, it's personal injury claims a tiny bit, insurance payouts a reasonable amount, and divorces. So big settlement that came in from that experience. And his job is to help people understand what money looks like, how to invest it, how to get a return from it over time, and that just because this money's here today, it's the whole baller basketballer situation where they have a short career, 6 to 10 years, they make $10 million a year, but then they become broke after 3 years because they don't know the skills around managing and growing money. And to your point about having the right advisors on board, making money is a very different skill from, as in making money from businesses is a very different skill from investing, and making money through different asset classes is a different skill from understanding how to navigate your way through a family estate and all the things that are sitting there. So, knowing what your specific strength is that you bring.
Pair your kids up with an advisor before you earn the money. Make them do the same as if I was going to try and get money from you. Here's my business pitch.
Yes.
Here's how you're going to make money out of me.
Yes.
Not everyone, people can have brilliant ideas and all the best advice, and it might still go wrong.
Yes.
But you can minimize the risks if you plan. And when there is money, what we do see, there's almost like this urgency to deal with it. I know that, you read in the paper the lotto advice that, when you've got money, don't tell anyone, don't even tell yourself, sit on it for 3 months, don't do anything. When you do have big wealth to deal with, that same advice, take time, but get that support in place and those plans before you start handing over the money.
Trent McElnoe came on the show, and through the terms of his company's sale, one of the founders was resident overseas, and so they had to leave the money in trust for 9 months, and it was a reasonably big sum. And he said it was the best thing that could have ever happened because they knew it was there, so they had the satisfaction and the ability to start planning for what that money was. But there was no impulse, no impetuous decisions made because they had time to think about it. It wasn't like there was millions of dollars in their account one day that wasn't there the day before.
It's really sensible.
Yeah. So we've talked around trusts, the terminology, what it means, how to go about settling one, what you need to bear in mind when you are doing so. And one of the things that you shared with me before the show was that there was a potential change that's coming up in New Zealand legislation, a proposed change in New Zealand legislation around death, estate, taxes potentially changing. Is that something you wanted to touch on today?
Yes. I mean, it's that the Greens have put out a view that there should be they're very pro-inheritance taxes, wealth taxes, and that there should be a tax on trusts. And while it's a small percentage, when you look at that as an annual tax, that you've got to think about, well, what would that achieve? Because there is this idea that wealth is bad, and that people use trusts to avoid tax. But actually, people settle trusts for a huge range of reasons, and anything that might start to affect the ability to support people in need, to keep businesses that are employing staff who are paying tax. It's a bigger picture look at it, I think, is really important.
Yeah, makes sense. Is there anything that I haven't asked that you'd like to share with us today?
I don't think so. I think the core thing is that trusts are not intrinsically good or bad.
Yeah.
It's if the circumstances are right and long-term intergenerational wealth protection is what you want, a trust is the only way you can do that. But making sure it remains fit for purpose, or any structure remains fit for purpose, reviewing your wills. I say to clients, whatever your asset owning structure is, if you've got children, choose a child, and every keystone event, go back and review your asset and estate planning. If you don't have children, choose something else. If it's a sport, if you're a sports fan, something that comes around every 4 years, or choose something, because however you own your assets, it's very unlikely that the structure you've got will work for your whole life. And so keeping it under review and not getting complacent.
Yeah, I love that.
And if you've got money, enjoy it. But I think the third is a really lovely way of looking at it. Do some good, support some family, and have some fun.
Yeah, very much so. Bill Perkins' Die with Zero is the name of the book. If you haven't read it, good read. So I asked at the start, I know that you have a vineyard up north, so maybe this is an alternate career, but the alternate universe, Vicki's super happy. She's got a different job that's not being a trust lawyer and settler and litigator. What would that career be?
In the office, we joke on the hard days, that's it. I'm going to become a florist. Flowers are never going to make you angry. Flowers will never say, Vicki, I don't agree with you.
Don't return your calls. Yep.
And I'm a mean-handed aioli. I do a very good aioli.
Okay, wow. All right. So
just a little
handy in the kitchen, plus you've got the vineyard, and maybe you could be an assassin in a different life.
Obviously, I'm not espousing physical violence, but, some days, a girl's mind wanders.
Yes, indeed. Vicki, what a great chat. Thanks so much for agreeing to come on the show. Very grateful for the knowledge, the insight that you've shared with everybody, and for people that want to be able to look you up, vatl.nz.
Thank you so much, Josh, for the opportunity. It's been a pleasure.
Thanks, Vicki. If you enjoy these episodes, I hope you do. I love filming them, and the guests always say what a great and often cathartic experience it is for them. Then please do like and share. Hit me up on LinkedIn. I'm open to connect requests, and occasionally get emails from people as well asking me about my experience around certain subjects. So please do like and share, and continue to follow the show. I really appreciate your ears.